Hello friends, I am Dr. Raman Mittal. I work at the Faculty of Law, University of Delhi. In this module, we shall be talking about assignments and licenses of intellectual property. That is, how intellectual property rights could be transferred by the owner to other persons, how the owner of intellectual property can invite others in participating in the exploitation of the works in which he has intellectual property rights. Now, where do you find licenses and assignments? What are the instances of it? We find them all around. Do we find it here in the bottle of a Coke? Yes, the bottle of the Coke that we consume comes to us only through the process of licensing of intellectual property. There are various licenses or assignments involved in the whole process of manufacturing, bottling and consumption of these soft drink bottles. Then the t-shirt that we wear carrying the logo of a famous character, that comes to us through licensing activity only. Then software that we consume is also subjected to licensing. In fact, we consume softwares as licensees rather than as buyers. In case of films, how the film comes to us, whether through broadcasting or through a cinema hall, it also involves the case of intellectual property licensing. The books that we read is also involving the case of licensing or assignment of copyright. So, we say licensing is ubiquitous, we find it everywhere. First, in order to understand the aspect of licensing and assignment, let us look at it from the angle of a lawyer. What are the tasks of an intellectual property lawyer? The first task is obtaining rights. The second task is, after obtaining rights, protecting those rights. And the third task is exploiting rights. So, obtaining rights and protecting rights cannot be ends in themselves, because what for are you obtaining rights? What for have you protected those rights? You have done so only with the aim of exploiting those rights. So, the fundamental task of an IP lawyer is to aid or to maximize or to monetize through the utilization or exploitation of intellectual property rights of his clients. Now, exploitation could be of two types: self-exploitation and exploitation through others. If the owner of intellectual property utilizes his own intellectual property himself, then is the case of self-exploitation of intellectual property. If the owner invites others or gives away his intellectual property to others for exploitation, then it is the case of exploitation through others, which is normally done through licenses and sometimes through assignments as well. Now, both licensing and assignments are transfers of intellectual property. So, let us go a step earlier and understand what is meant by transfer of intellectual property. Is intellectual property transferable? Yes. Intellectual property rights, most of the, we can say, the intellectual property rights are transferable in nature. These transfers could take place either by the mechanism of a contract or a mechanism which is apart from the contract, which is, for example, by operation of law. For example, the owner of intellectual property dies, so his legal heirs will get the intellectual property which was owned by the dead person. So, but the most important one for our purposes is the contractual transfer of intellectual property. Contractual transfer of intellectual property could be achieved in the form of assignments, lease, license, mortgage or sale. All these are legally different and significant aspects and concepts of law, and they convey very different rights and very different meanings and very different consequences. Now, most important types of contractual transfer of IP or intellectual property is through assignments and licenses. So, licensing activity gets impetus from three fundamental aspects of law. First is the rights which are contained within intellectual property, they are of exclusive nature. This exclusivity of rights aids the activity of licensing. What is understood by exclusivity of rights? Now, the rights exclusivity means that the owner alone has the right to exploit his intellectual property. So, we can look at this aspect of exclusivity from one angle, that means the restrictive angle that gives the owner a right to exclude others. But the other aspect of this exclusivity is that the owner has the liberty, has the freedom to invite all others to partake in the exploitation of his intellectual property. Thereby, he will be allowing others, permitting others to participate in the exploitation process and also earning for himself some remuneration. So, this aspect of exclusivity really aids the licensing activity. The second aspect is the intangibility of intellectual property. Intellectual property, we understand, is intangible in nature. Now, the enjoyment or the utilization of this intellectual property being intangible property does not detract, the use of one person does not detract from its use by the other person. Potentially, any intellectual property could be utilized by any number of persons. It is in contradistinction with a physical property. For example, somebody A owns a house. In case he wants to allow B to utilize his house, then the house has to be divided between A and B. So, that is not the case with intellectual property. Both A and B can have the same, and any number of persons can have the same property for its exploitation. So, this intangibility or intangible nature of the intellectual property also aids the licensing activity, because the owner can invite n number of persons for its exploitation. The third aspect is that gives impetus to the licensing activity is the freedom of contract. The law permits the owner to freely contract out his property. This freedom of contract also aids in the licensing activity. Intellectual property, as we have seen, has three limbs. First is creation of property, then second is protection of intellectual property, and third is its exploitation. So, one question is fundamental to this circle of intellectual property. Should a property be created first and then protected and then exploited? In other words, is it always the case that intellectual property is created first and then exploited? Well, that is not always the case. That may be the case in some times, but the modern practices of the market, if we peep into those modern practices, we find that exploitation of the property takes first and then the property is created only upon its exploitation. For example, there is a person who wants to make a film, he is a film producer. So, first thing he requires is a script. So, he commissions Mr. A to write a script for his film. So, for that he already pays Mr. A upfront a particular sum of money. So, can we say that the property, intellectual property, copyright was created first and then exploited? In this case, no, because the property was subject to sale first and then it was created, because only upon an assurance of money and actual payment of some advance money that the author was ready to create it for the producer. So, in this sense, we can also see the modern practices in which inventions are made. Employees are people are employed in business undertakings, they are given certain tasks, and before they create something, they already have assigned by virtue of their employment contract to the employer the rights in all their creativity. So, exploitation many a time comes before creativity and protection in case of intellectual property. Now, what is the role of licensing in business and economy? The first question is intellectual property wealth in itself? Well, we say that in the knowledge economy, intellectual property is wealth, but intellectual property is not wealth in itself. It can be converted into wealth by its exploitation, and licensing is the major way in which intellectual property is exploited. The second question is it really possible for the creator to utilize his property himself? Well, that may be the case in many cases, but in most of the situations, the intellectual property is utilized by somebody who is not the owner. That means the owner invites somebody or permits somebody to utilize his intellectual property, and that permission is known as a license. The third question is it possible or feasible for businesses to create everything in-house in the modern economy? Well, no. Mostly businesses business these days is a collaborative venture. So, you cannot create all the intellectual property that you want or that you require for your business. Many times you create some intellectual properties, and license in the others that you require. We know it as a fact that the greatest economic value of intellectual property in the modern economy comes from licensing. So, licensing is indispensable to the modern economy. That is the role licensing plays in the modern business and economy. Licensing is also a strategic tool for innovation in various ways. First, licensing allows the owner of intellectual property to concentrate on his core competence. For example, there is a research institution. Now, the core competence of that institution is to do research, is to do fundamental research and make new inventions. That research institution may not be and is not usually competent to take the invention to the industry and thereby thereafter to the market. For that, we have industrial houses and marketers. So, licensing allows this research institution to concentrate on its core competence, that is creativity, that is invention. So, once they invent, they can utilize this instrument of licensing to transfer their invention to the market entities, to the industrial entities, thereby earning through in the form of royalty income. Now, licensing further allows you to access new markets throughout the world. For example, there is a owner of intellectual property, he has his markets in India, but then he wants to expand to Europe. Now, he has no presence in Europe, he has never done business in Europe. It may not be possible for him to directly take his property to Europe for marketing. Thereby, therefore he can use the instrument of licensing and license an entity, a business entity or a marketing entity in Europe to take and sell his property, intellectual property in Europe. Thereby, licensing allows you to grow, allows you to access new markets. Licensing also allows you to test new markets. For example, the same businessman wants to expand in Africa, but he does not know about the business climate, the business environment of Africa. So, before he ventures himself out in Africa, he can test the market through a licensee. He can first license his property to somebody, a business entity in Africa, and if that venture is successful, then he can think of going to Africa himself and doing business himself. Well, licensing is an instrument of turning an infringer into an ally. Normally, infringers are seen as opponents or as seen as enemies of any intellectual property holder, but that is a very impragmatic view and very primitive view. Who is an infringer? Normally, an infringer, if I am the owner of an intellectual property, an infringer is a person who needs my property in the first place, two, who knows how to exploit it. So, if I can shake hand with the infringer or compel him to shake hands with me and try to sell him a license, then he can do whatever he was doing before, he can do it just by paying me my share of his earnings, that is my royalty. Thereby, licensing allows the conversion of an infringer into a friend. Licensing allows the utilization of intellectual property that the owner does not use himself. In the course of its business, a business entity might create a lot of intellectual property, might generate a lot of intellectual property like copyright, like trademarks, like patents, like inventions, etc. So, all those properties are not needed, may not be needed by that business for all the times. So, what to do with the intellectual property that is still current, that is still called an intellectual property which has not passed in public domain, but it is not utilizable by the owner himself. So, he can invite others and grant them licenses over the redundant intellectual property which is of no use to him, but which can be of use to many other persons. Then licensing also allows you through spin-offs to take the technology or invention which was made for a particular cause to be utilized for a totally different cause. For example, our past president Dr. APJ Abdul Kalam invented carbon material, which was invented for space vehicle program because they wanted to make the weight of certain components to be very less. So, this carbon material really reduced the weight of the components, space parts or space components significantly. So, the same technology was used for making artificial limbs of persons who had no limbs. For example, a person has no legs, so we were in search of such a material which was less in weight and at the same time very sturdy. So, this material which was invented for space technology was ultimately utilized also for making artificial limbs. So, all this through the instrument of licensing. Licensing is a strategic business tool, is sort of a partnership, is sort of a joint venture. So, it is a joint venture between the owner of intellectual property and the person who has the ability to exploit it. So, the owner himself may or may not have the ability or willingness to exploit his property. So, he can invite the person who specializes in exploitation of the property and thereby make a joint venture with him. For example, take the case of the author of a book. The author of the book knows how to write the book, but then he does not know how to print and publish the book. He may not have any market presence to market his book, to sell his book, to take the book to the consumer. For that, if he utilizes the instrument of licenses and allows a publisher to take over this aspect of the distribution, publication and distribution of the book, then he can concentrate on his core competence, that is creation of the book, writing of the book. Thereby, there is a division of labor, and through this joint venture, the book is ultimately taken to its audience. Now, what exactly is licensing? Licensing, legally speaking, is convergence of intellectual property and contracts. Primarily, law of contract and IP combine to form the body of law that is known as licensing law. Professor Raymond T. Nimmer, who has authored one of the most important books on licensing of intellectual property, stated, I quote, "Thinking of contract and intellectual property as isolated and discrete boxes of principles is an impoverished idea. Law as a practical discipline relates to human activity which defies being boxed." So, if we dissect licensing law, what do we find? First, it is comprised of law of contract, because every license has to be a contract first. Now, where is this law of contract contained? This law of contract is primarily contained in a statute in India, which is known as the Indian Contract Act of 1872. Further, this law of contract in case of licenses is also contained within intellectual property statutes. Most of the intellectual property statutes like Copyright Act 1957, Patents Act 1970 and Trademarks Act 1999, they contain elaborate provisions as to contracting activity in case of the respective intellectual properties, whether it is copyright, patent or trademark. So, contract law is contained within the Contract Act as well as within the intellectual property statutes. Then licensing law is also comprised of intellectual property law. Further, competition law has a lot of bearing on licensing activity, and most of the competition law issues that arise in case of intellectual property arise in case of its licensing only. Then consumer protection law is also called within licensing law fold, because many times the consumers are licenses. For example, we consume computer software by becoming licensees, and the provider of the computer software is the licensor. So, the provider of computer software, say Microsoft Windows, is not the seller of computer software, he is only a licensor, and when we buy Windows, we become licensees of the Microsoft Corporation. Then taxation law also has a lot of bearing on licensing law, the treatment of royalties, how royalties are to be distributed, what will be the taxation upon those royalty income, etc., they are all governed by taxation law. So, licensing law basically is an amalgam of all these different doctrines of law. Next, we come to the influence of intellectual property law on license contracts. First, intellectual property law defines the scope of the rights, that means the consideration part. When A and B agree, whereby A and B agree to form a contract, whereby A agrees to grant his intellectual property to B and B agrees to pay in return for that grant, what has happened? A transfer of intellectual property. So, the scope of that intellectual property, the scope of that transfer is to be measured in accordance with the law of intellectual property, because it is the law of intellectual property which defines the exact scope of the property, and thereby defining the exact scope of law, exact scope of grant. Intellectual property law may provide for requirements over and above the requirements of general contracts. Many times the general contract law may not provide some requirements, for example, writing or signatures, whereas intellectual property law may go above the general law of contracts and provide for such requirements. It delineates the scope of the license by laying down the contours or establishing the contours of the exact rights, the scope of rights that are available. It determines the scope of a license. Intellectual property law many times also provide the default or background rules for a license. The parties to a license may assert certain rights against third parties who are strangers to contract. For example, the law of contract says that only the parties to a contract can sue and be sued upon the contract. But in case of intellectual property law, there are exceptions made to this fundamental rule of contract law, which is also known as the doctrine of privity of contract. Intellectual property law may also provide for compulsory licenses. Normally, contracts are free. We have the theory of freedom of contract. If the party owns something, he is free to contract it out. But in certain cases of regarding intellectual property, the law has provisions for the grant of compulsory license. That means if the person wants a license, he is not required to go to the owner of the intellectual property. Instead, he may go to the state and obtain a license from the state, which is known as the compulsory license. Apart from compulsory license, there is also a provision for statutory licenses in various statutes like Copyright Statute, Copyright Act of India 1957. So, it contains provisions for statutory license. Now, what is a statutory license? Statutory license is a genre of compulsory license where the statute itself has granted a license to everybody, whosoever is willing to comply with the conditions laid down in the statute itself. So, intellectual property may also provide that certain intellectual property certain intellectual property rights are not transferable or not licensable or not assignable. That is, for example, we can say that in case of section 18, which was recently amended in the 2012 amendments to Copyright Law of India, whereby certain rights of the author are not assignable. Intellectual property may provide for additional non-contractual remedies as well, which we shall see during the course of this presentation. Now, if we see licensing as a subject of study, we can see it as a limb of intellectual property system. We can also see it as a limb of commercial law, and if we adopt a unified approach, licensing has also become a unique discipline in itself, because there are certain legal professionals who identify today as licensing professionals only. So, licensing has become quite complex in the modern context, and there are organizations like Licensing Executive Society International, which enrolls members who are licensing professionals who practice this discipline of licensing worldwide. Now, we come to the contractual aspect of a license. Contract is the vehicle of license. Contract is the only means to affect an intellectual property license. There is no other way, it has to be a contract. Now, all the essentials that are required to be complied with in case of a normal contract, in case of an ordinary contract, are also required in case of a license. Now, there are certain aspects which need a little more scrutiny. For example, writing. Is a contract required to be written down to be enforceable, to become valid? No. As far as the general contract law is concerned, writing is not the requirement. An oral contract is as enforceable and as valid as a written contract. But certain intellectual property statutes, for example, the Copyright Act and the Patents Act, require that the contract should be in writing. Contract of the license, intellectual property license, has to be in writing to be enforceable. That means, if the contract relating to intellectual property is not in writing, then it may not be enforceable. Certain statutes also require, in addition to writing, the requirement of signatures. Normally, no notice of the contract is required to be given to any party. Further, as far as registration is concerned, some intellectual property statutes require registration and some make it optional. Even if a particular intellectual property statute has no mechanism for the registration of a particular license, as a legal document, it can always be registered under the Registration Act of 1908. Now, what is the relationship between licensor and licensee? First, the relationship is contractual. Further, there is no assumption of fiduciary character between or fiduciary relationship between the licensor and the licensee. It is a contract between a principal and a principal. The licensee is not necessarily an agent of the licensor. The contract is between principal and principal. Rights of licensee flow from intellectual property law as well as the contract law. Now, what are the types of licenses? First, license could be exclusive. An exclusive license is very similar to assignment. Now, what is an exclusive license? Exclusive license is a situation whereby the owner of intellectual property agrees with the other to grant a license exclusively. That means the owner of the property says that I shall not grant any other license to anybody else. Further, the owner promises that he himself shall not be exploiting that intellectual property which is the subject of an exclusive license. So, that means the licensee becomes the only person entitled to exploit the licensed intellectual property in case of an exclusive license. Opposite of it is non-exclusive license. Non-exclusive license is only a promise, is just a promise by the owner not to sue the licensee. There is no promise that he will not grant any other license to anybody else, or he himself will not be utilizing his property in future. So, non-exclusive is the opposite of exclusive. Sole license is somewhere in between. Sole license is a genre of non-exclusive license only. Sole license means that the owner of intellectual property says that you shall be, says to the licensee that you shall be my only licensee. That means the owner cannot issue any other license to anybody else, but he himself remains free to exploit his property. Now, statutory license we have already seen, where the statute itself grants you a license on return of fulfillment of certain conditions which is lays down. We have also seen what is a compulsory license. For example, the patent law allows or creates a mechanism for the issuance of compulsory license in case of public health emergencies, etc. These are the important aspects or types of licenses. Now, the division of license rights, it could be divided in any license could be divided in 4 ways. One is geographical. That means you can divide the licenses over the same property geographically. For example, you have a product and you can allow somebody to sell it in one particular geographical area and the other to sell it in another geographical area. So, for example, I am the author of a book. I can allow one publisher to publish it for America and another publisher to publish it in India in the same language. The division of license rights could also be temporal. For example, I can allow, I have a new technology and I obtain a patent on it. I can grant a license to a manufacturing entity to manufacture and market the technology that I had invented for 5 years, and thereafter that entity will not be entitled to do the same. So, it can be divisible on temporal basis. Then substantive, I can divide, because intellectual property is divisible, the rights that are granted under intellectual property are divisible. For example, I write a book, I can allow X to make a film on the book, I can allow Y to translate the book, I can allow Z to adapt the book. So, different aspects of the rights can be apportioned differently. Then field of use, I can, if I am the inventor of a technology and obtain a patent on this, then I can license X to utilize it in the field of medicine, I can allow Y to utilize it in a field which is something very different from medicine. So, field of use could be different and it could be apportioned or divided on the basis of field of use. Now, what is the difference between license and assignment? Now, the nature of transfer is very different. Assignment can be analogized with sale and license can be analogized with rental. For example, I have a house, if I sell it, it will be called an assignment in relation to intellectual property, and if I allow somebody to make use of it, it will be like hiring, giving the house on hire. The title, the licensee of intellectual property gets no title to intellectual property, whereas the assignee gets the same title as the owner, he himself becomes the owner. The right to sue. Normally, a licensee has no right to sue the infringer of intellectual property, but some statutes like Copyright and Patents Act have granted limited rights of suing of pursuing the infringers. Those limited rights are available with certain kinds of licenses like exclusive licenses. Otherwise, the licenses have no rights, no independent right to sue the infringer or pursue the infringer, whereas the assignee always gets the right to sue the infringer. Now, breach and infringement. In case of breach and infringement, the rights and responsibilities of the breaching parties are quite different if he is a licensee or an assignee. The consideration for license is usually in the form of periodical payments known as royalties, and the consideration for assignment is usually in the form of a lump sum payment. Now, how to know whether a contract is a license or an assignment? What is the importance of a label? For example, a contract is styled or labeled as a license. Would it always be a license? Well, no, it is not necessarily so. It is the substance of the contract that determines whether it is a license or an assignment. It is not the talismanic phrase by which it is styled or described that would always be determinative of its nature as a license or assignment. It is the content, it is the substance of the contract. It is the rights that are transferred that would determine whether the contract is a license or assignment, the manner of transfer and the intent of parties. Importance of label is there, but label itself cannot in itself decide whether a contract was a license or an assignment. Now, we come to trademark licensing, certain examples from trademark licensing. Now, in the beginning of trademark law, if we trace the history of trademark law, licensing was not permitted, because at that time we went by the theory of single source function. That means a trademark was required to identify the source of the product. So, if the product was emanating from A and henceforth A licenses his trademark to B, then the consuming public would always think that the product is coming from A. Thereby, it will confuse the consuming public. This is why licensing was not permitted and specifically prohibited in the trademark statutes before 1930s. But then, with the development of trademark law, the consumers were more concerned with the quality of product than with the source of product. If I want to consume a bottle of a soft drink, I am more concerned about the quality. As long as I get the same quality which is made by the Coca-Cola company, I am satisfied whether it comes from any other source with the authorization of Coca-Cola company. So, this shift in the nature of consumer behavior and shift or development in the trademark law allowed licensing for the first time in 1930s. So, thereby it was stated that as long as the quality of the licensee's goods are controlled or regulated by the licensor, licensing is permitted. Now, that means the licensor was required by law and is still required by law to maintain the quality of the products or the services of the licensee. That means what? Should the product or services of the licensee be of the higher quality or the highest quality? No. The measure of the quality should be the same as that of the licensor. If the licensor is providing X quality, then law expects the licensee also to provide X quality, because in this case the consuming public will not be confused. And then, with the merchandising function of trademarks, licensing of trademarks has come full circle. In the modern world, what is merchandising? For example, when I take my kids to the market to buy a t-shirt, they are specifically interested in a t-shirt which contains the logo of their favorite cartoon character. So, what has happened? For example, they want a t-shirt with Mickey Mouse printed on the t-shirt. Has Walt Disney Company, which owns rights over Mickey Mouse, produced that t-shirt? No, certainly not. Walt Disney Company produces films, not t-shirts. So, what has happened in this case is that Walt Disney Company has authorized or has licensed an independent manufacturer of t-shirts to put that label on the t-shirt, to put that logo on the t-shirt. Now, this happens only because of licensing. Now, we have moved away from quality control function, because in this case, because quality function stated that the quality of the licensee's goods should be similar to that of licensor in order for licensing to be permitted. Now, in this case, Walt Disney Company has never produced t-shirts. So, how can we measure the quality of the t-shirts with the quality of the film? So, we are going beyond the quality function in trademark law. Now, licensing of registered and unregistered trademark both is permissible. The Trademark Act of 99 in India contains elaborate provisions regarding the registered trademark being licensed, whereas the licensing of unregistered trademarks is mostly governed by the common law of passing off. Now, in case of registered trademarks, the statute, the Trademarks Act, provides elaborate mechanism of its registration, and there are various advantages that flow from registration. Whereas it is not, the statute has not made it compulsory for a license to be registered. There is another fundamental principle in case of a trademark license. It is that the use made of the mark made by the licensee always inures to the benefit of the licensor. Section 48 subsection 2 states that the permitted use of a trademark shall be deemed to be used by the proprietor thereof, and shall be deemed not to be used by a person other than the proprietor for the purposes of section 47, or for any other purpose for which such use is material under this act or any other law. Now, what is the meaning of this? Legally speaking, we say that if A is the owner of a trademark X and A allows B to use X for its own purpose, then who shall have the rights on the basis of that use of the trademark? The law says it is A, and B shall not amass any trademark rights on the basis of his use of the mark X by virtue of being a licensee. So, in order to summarize, we can say that licensing is the most important activity that happens in case of any intellectual property, and intellectual property is created ultimately for its exploitation, and one of the most important means of exploitation of intellectual property is licensing. Licensing is of various kinds like exclusive license, non-exclusive license, sole license, statutory license, compulsory license, or cross license. Now, there are fundamental differences between assignments and licenses. Both assignment and licenses are contracts, but they entail very different legal consequences. A license can be analogized to a rental of a car, whereas an assignment can be analogized to a sale of the car. Thank you very much.